I know when you asked me to come to Chennai to be physically available, I declined with a lot of hesitation, you know that. And to speak to receptive audience, whether they are students or public platforms where these ideas are to be shared, is always a great pleasure. Of course, Tamil Nadu, in one of the conversations when two judges were talking about the new Attorney General, a judge from Tamil Nadu told the other judge, I'm not talking about, praising myself, or he said, Tamil Nadu has always given intellectual giants to the Supreme Court, whether they are judges or lawyers or attorney generals. So I felt very happy about the judge talking to another judge this way, not because it is about me, but because about Tamil Nadu. So we have that rich tradition where wisdom, maturity, and scholarship, coupled with the persuasive skills of carrying an idea to an audience who might be, completely alien to certain thoughts and thought processes. And so thank you for being with you today evening. And when you wanted to talk to me, talk about the Constitution, and you said probably I can pick up any aspect of the constitutional idea. You also mentioned about two other previous speakers, one of the former judges of the Supreme Court, whom he said that the Constitution probably should have had something more about the elections and the role of Election Commission. And you also said another speaker said something about the importance of dealing with crime, criminal law, and things like that in the Constitution. So as I was thinking about those ideas which you shared with me, and I was wondering whether we can talk about what should a constitution have and should not have. So is there an ideal constitution which is available to us, which you can gather today from any part of the world, like the prayer book, which is ideal for Indian religion. I don't know whether we have any such ideal constitution in any part of the world, which can tell us what a constitution should have and should not have. But we all have ideas of constitutions and their growth over a period of time, whether in Europe or in USA or in some of the Asian countries, post-colonial exist. A very interesting thought while I was thinking about is, America had a constitution way of 1789 or so. And by 1791, they had about 9 to 10 amendments to the Constitution. By 1798, there are a couple of more amendments to the Constitution. And you will see just probably 100 years earlier or a little later, the European countries began on a colonial expansion. America did not engage on a colonial expansion as the European powers did. Is it that because the 13 colonies, which contained the people who had traveled all over from different parts of Europe to settle down in a new country of their own where freedom will flourish, they did not think it is important for them to go and colonize the rest of the world. They wanted to explore for themselves how to be really a free country with all the potentials of freedom that was made available to them. On the contrary, by that time, except a few countries in the European continent, had any meaningful constitution, a written constitution. The great colonial hegemonical empire, the British people, did not have a written constitution, and though they pride themselves that they have a great unwritten constitution, it is as good as a written constitution. There were some experiments in Prussia, in Germany, and few countries in Europe which could be probably credited with a written constitution by the time America had its constitution. So maybe it's interesting to note that a country which had gathered under a new umbrella of a constitution did not think it's important to colonize the rest of the world. When we talk of colonizing, well, Europe went about colonizing not only geographically, physically, but also intellectually, spiritually, religiously, and so on and so forth. So the colonization part which happened, very interesting again to note that the outcome of this great colonization experiments is again the birth of constitutions across the world. If colonization has not happened by reason of the European powers expanding across the globe, one wonders what would have been the history of constitutions across the world at all. And one also wonders whether if the Europeans had not engaged in interminable wars, the wars between two religions, the war of crusades running over 100 years in Europe between Christianity and Islam, and each religion killing itself like anything. And in the absence of two world wars, whether we would have had the birth of important ideas about the constitution and the rule of law, etc. So it's because that the European powers not only began to colonize, but they were in internecine warfare among themselves, that you had all these wonderful ideas of freedoms, liberty, and so on and so forth. That's as far as what one can think about the reason why constitutions such as the Indian Constitution or some of the Asian constitutions have received the color from the rest of the world. So, but then, is it that we talk about Constitution of India only from the point of view of Western ideas or ideas of Europe and so on and so forth? Is a very important question to be asked. We have about 74 to 75 years of independence working on the Constitution. I sometimes think that about 300 years of US constitutional history is equal to probably 1/3 or 1/4 of our constitutional history for a number of reasons. Within less than 30 to 40 years of our constitutional history, we have reached several watersheds in understanding and the working of the Constitution. And post-emergency, we have also traveled very quickly with a great amount of speed and expedition in capturing important dimensions of freedoms of the people, much more than what a US Constitution has been able to do in the course of about 200 to 300 years. One may explain them by a number of factors. And you can fall back on social and political theory or what to find out whether America had any history at all before the American Constitution was ever born. So the American people did not have any history as America before the US Constitution, but then India has a different story altogether. There are certain sections of political thinkers in our country, the left and the liberal thinkers, who seem to think that the Indian history has no role to play in the making of the Constitution and the sustenance of the Constitution. I think we need to differ with them. This genre of thinking, whether it is liberal or leftist ideologies, which are grown on an entirely alien soil, on the understanding that with the revolution, a complete reordering of a social structure can be achieved, is now seen to be a failed promise. We have the great examples of USSR and the East European countries as well as China. So the thinking that with a revolution, social ordering can be done rested on the great belief that people will become wiser after a revolution, and that there need not be any spiritual, religious, cultural, or other underpinning. Like, of course, whether you believe one believes in this notion or idea, as we talk about, namely that India is rooted in certain philosophical, spiritual, and cultural underpinnings which have guided it. What exactly the ultimate aim of a human life? The question which we have been asking thousands and thousands of years ago. I think that's an important question which always guides a country and a nation in its civilization march. If that question has not been asked, then you only ask different questions. Namely, how do we have a social order? What kind of freedoms we can have? Whether we should have freedom for all or will have freedoms which are available to a few. If you keep asking a socially, politically relevant question without asking a civilizationally important question, I think the differences become very visible, as I was talking about, namely the examples of Russia or China. So we still have all those debates in European political thought, namely that fundamental freedoms for all are important, equality is important, and equality and fundamental freedoms can be gained only by a social order where governance is accountable, and that accountability in governance can be secured only by a constitution, and that constitution can only function if it is again managed on a mature basis with the three organs of the government. These are the constitutional debates that go on and on and on, whether in Europe or in USA now. After 1948, the Universal Declaration of Human Rights, the debates have become more entrenched with the aid of the concept of human rights. I'll come back to it a little later. But the point I thought we need to understand is, today there are a certain dialogue in our country which says, are we not undergoing a constitutional crisis? Are we not undergoing a challenge to rule of law and equality or equal regard for all? Are we not undergoing a challenge in terms of certain ideas and thought processes, or trying to silence the rest of the community, so on and so forth? What is the root cause of all these questions? So I think it's important for us as people to understand that. I know when I'm talking to those in Tamil Nadu has certain other important facets of the same set of questions. We see the resurgence of debates such as Aryan rebellion, invasion, Aryan Dravidian differences, the Tamil versus other languages differences, and all that kind of things, we see a resurgence in Tamil Nadu. One must understand and try to ask this question: why do they happen at all? And if at all they happen, is there a reason to be worried about it? I think not really as a constitutional lawyer, but as a citizen of this country, and having seen the Supreme Court functioning in different areas, namely the pre-emergency and the post-emergency area, and particularly post-1980, the role played by Supreme Court virtually in every aspect of our life. I've come to believe that these questions, the kind of questions which say that the Indian Constitution or Indian governance is under great challenge, is a facile question. Is a question that is being posed only by a certain minimalist minority section of the community, and for a number of reasons. I don't wish to get into that kind of reasons which are relevant. But for us, it's important that if at all we are talking about a constitution, I think India's great history has played an important role in not only the people of India receiving a constitution and keeping the constitution intact. When the 13 colonies in USA wanted to be together, they formed themselves into a confederation and the United States of America, and they gave to themselves a constitution to govern themselves. But India was already, in a larger sense, a country with a rich spiritual and philosophical understanding, where namely the fundamental question as what will guide each individual's life. That question has been part of our innate sense of understanding of life, and we grow in that framework of mind. And that question and that understanding, I think, has richly contributed very silently, quietly, and invisibly to the reception of a constitution. So unlike USA, where they gave themselves a constitution, we received a constitution, even though the constitution was a product of 3 years of constitutional dialogue in the Constitutional Assembly. But that's a very small matter. So again, if you look at what happened in Europe between 1700 to late 20th century, not less than 175 and odd constitutional experiments have taken place. And in the rest of the world, post-colonialism, the authors talk about several waves of constitution making. But important for our purposes is the post-World War I, post-colonialism, and post-World War II emergence of constitutions and idea, and the sustenance of a nation as a constitutionally governed country. So if you look at all these experiments happening across the globe and the aspirations of people in trying to live under a common umbrella of an idea of a constitution. So it's important for us to comprehend what exactly the idea of a constitution India has received, has impregnated as part of its spiritual and other traditions and culture, and have been able to showcase to the rest of the world what could be an ideal constitution. I think these are important dialogues for a common people to be engaged. So just to digress from these broad reflections. Now, today everybody keeps asking the question, why should Supreme Court enter into every aspect of our life? Why should Supreme Court say we have a fundamental right to sleep, we have a fundamental right to do this, a fundamental right to do that, and why should government not be free from freedom to act the way they would like to act? And if you ask the same question in America today, it has a different color. So why should Supreme Court talk about abortion? Why should Supreme Court talk about the orientation of people in their personal lives? So one important aspect that has grown across the globe, including India, is the role of the court. And sometimes one wonders whether without courts such as the Supreme Court, a country's governance, its rule of law, or would have been probably as firm and certain as it would be otherwise. So the role of the court has become an important element of the Constitution's idea and the constitutional function. So for the common and who go to vote for every 5 years, and we know that while we vote, we have our aspirations, and while aspirations try to influence and persuade our understanding of who should come to power, we are all bound by a certain identity. Our identity as a religion, our identity as a language, our identity as this or the other factors of our life. But in the rest of the world, these identities have been divisive. But in India, the identities have not been divisive. That's a very important aspect. Regardless of the identities in our country, with the rich diversity of religion, faith, language, culture, we are not really divisive as a nation. That's why I would like to dismiss those set of people who talk of the dangers of emanating from the fringe elements of the divisiveness, dialogue and debates in political aspects. To give a few examples on why the role of the court is important and how the people of India have received and the role played by the court and has probably integrated the ideas handed out to the court into their everyday life. Let us look at some of these examples. If you look at the early years of the Republic, who went to the High Court and Supreme Court? Very ordinary men and women went to the High Court and Supreme Court. There's somebody who had a problem with the prohibition law in Bombay, went to the Bombay High Court and later to the Supreme Court, said, I have some problem with this idea of interfering with my freedom to consume liquor. So somebody who had probably had a problem with law dealing with a question of flesh trade went to the Allahabad High Court and much later to the Supreme Court. And so these are the common men or people who are talking about when Mr. Hanif Qureshi, So people who went to the Supreme Court at the early point of time where ordinary men and women were talking about their common pursuits of life. And when Supreme Court in the early days came to their rescue and began to deal with the Constitution in interpreting the rights, very important for us to notice the way the early Republic, the Indian Supreme Court began to look at rights, and the way Supreme Court of India is beginning to look at rights today, there seemed to be some kind of a sea change. Some paradigm shift seemed to have taken place. Probably that's an apparent level. But if we look at it a little deeper, every important pronouncement of the Supreme Court, whether in any aspect of the freedom of speech and expression, or the right to religion, or the right to carry on trade, etc., you will find some fundamental civilizational values of India has always inspired and persuaded the Supreme Court to maintain a balance. And I think that will continue to happen. While in some important areas, Supreme Court apparently seem to be, or debated to be overstepping its limits. And that's a very important debate by itself. Because unless people engage in a debate, for instance, while I was traveling in USA and getting into a conversation with a cab driver, so he asked me, where do I come from? So I said, I'm a practicing lawyer in the Supreme Court. And he said, sir, the US Supreme Court in Brown versus Board of Education did all that nonsense, things like that. So I was really happy to know that a cab driver could engage a foreigner on a constitutional dialogue. So today, I think our women and men, in the common pursuits of life, are in a position to engage in such dialogue and be part of and participating actively in the constitutional functioning and life of a country. And why did it happen? I think it could have happened only because the Supreme Court comes in a large measure to deal with the problems of the country, whether through finding fault with governance or adding luster and importance to the governance and adding meaning to governance. For instance, look at when the Supreme Court said in 1993 that the right to freedom of speech and expression, which is a fundamental right, includes the right to know. And the right to know today means whoever we want to elect must be bound to disclose their antecedents. Therefore, the right to know has become a part of the right of freedom of speech and expression. How enriching this has become for enhancing democracy and adding strength to the electoral process in our country. Well, we still know that criminalization continues to be part of the electoral process, and the kind of ideal representative we would like to have in our assemblies and parliaments is still a faraway dream. But we have created and all those necessary tools and instrumentality. Then somebody may ask me a question, all right, it's fine that Supreme Court of India and all that, but then look at the American Constitution. It is a slender constitution. Mr. Palkiwala long ago used to say that, look here, the Indian Constitution is so unwieldy and compared to a very slender constitution like the American Constitution. And why do we need to talk about this kind of comparisons at all? I don't want to be too scholarly and then talking about concepts and ideas which may have a lot of underpinning. I want to be as common sense as possible. So the American Constitution, amended only about 14 to 15 times in the early part of its republic, thought that only few seminal ideas must be in the Constitution. If everything about our life, from the toothbrush we use in the morning to the night shelter people need at nights in cold winter, if everything needs to be a matter of a constitutional idea and a constitutional provision, then what is left of governance? What is left of ethics and morality of governance? What is left of ethics and morality of people in trying to be creative, innovative, and continue to be engaged in enriching and transmitting the spiritual, philosophical, and cultural traditions of our country? I suppose, therefore, a constitution must be minimal. The moment it becomes too unwieldy, it leaves little room for the people to be really governing themselves. If you look at constitutions in a country like China, it is neither too minimal nor too big. but then it doesn't have the scope for people to be participating in the governance of their own lives. So after more than 60, 70 years, 1917 was the Bolshevik revolution in Russia. But 1993, when Russia broke, now they're all talking about what next. So they did not have a spiritual, philosophical, and dharmic underpinnings of a history to guide them as to move forward. So today there is a lot of chaos in terms of economic and political ideas in a country like Russia. East European countries are still finding their way through a number of ways. The Yugoslavia and Czechoslovakia fought the worst of the ethnic wars. So why that all that's happened in a Western, European setting, where they are all the what's called the knowledge of the West. I wonder whether therefore the historical, spiritual, and cultural tradition in the richness of a country is one important factor why the reception of an idea of a constitution is further enriched by the people of that country. I think India stands, in a tall way as far as the score is concerned. So I would probably think in terms of a constitution which will be minimal, and also at the same time, today when we think of the conflict between different faiths and how do you really manage them? Is there a need for an idea beyond the dharmic and historical, cultural underpinnings of a country to have more and more legislations to manage the diversity of our faith? And whether more and more legislations or more and more addition to the constitution will do the magic and wonder, I have my doubts. I think it's important as people of a country, the people of a country, our own ethical, moral strength, and our ability to manage our own affairs, and our strong belief that diversity is part of our life. Did not any part of our whether it is the Upanishadic literature or the great Tamil genre in Tamil literature, look at any one of them. I think the great contributions made there is human beings in their ethical, moral responsibility are the best guardians and the custodians of rights and duties. And that idea is a very important idea, I think, which must go deeper and deeper as we move further in managing our constitutional ideas and constitutional culture. So when Shantaraman asked me about, sir, why don't we talk about what more can be added in the constitution, my answer is this. It's better that we don't add anything more in the constitution. We have added enough. By way of a physical addition. By way of physical addition means more amendments. I don't think we need any more amendment to the constitution in the sense that we have had more than 100 and odd amendments to the constitution. People ask this question, if what you are talking about is so great, that we are great managers of our own constitutional functioning, why did we need this kind of amendments? The answer lies elsewhere. The post-emergency and the pre-emergency amendments stand on a slightly different political background. I would like to look at the post-emergency constitutional amendments and look at why global impact has made a world of difference to the need for certain amendments to be brought in. Questions are also asked as to why, all right, it's very fine, but why did our political parties not become wise enough to manage themselves in a mature way? We still find political parties with all kinds of colors and hues and their own divisive languages. Then don't you think that there's a need for a stronger central force which can keep political parties under constitutional control and regulation? I'm not very sure about that. It's important for us to say that before, let us say, the TN session days, when the way the elections are held in this country, and minimal changes in the electoral machinery, and all those little additions, informal additions, not constitutional amendment to the election law, informal additions to some kind of legislation or some rules, regulations, so on and so forth, to the electoral law has made a world of difference in our country. So we don't need an Arab Spring at all here. And So the election law, changes in the election law, post-emergence and minimal incremental election law has contributed to the people's understanding that we need to keep moving ahead and further in ensuring that political parties become accountable, that elections become more and more transparent, that will be able to participate in a more enriching and enduring way in managing our own elections. These are all ideas which become part of almost our everyday thinking. So you look at our social media writes-up today or our write-ups in our newspapers or debates in media, visual media. It's important to notice that people talk about all this. So how did it all happen? Not because we have written too much into the Constitution. So as far as elections are concerned. But the post-emergency, some constitutional developments and constitutional amendments, like for instance, Supreme Court has begun to question almost every aspect of powers of the president and the governors. So the governor's power to dissolve assemblies or, very minute aspect of monitoring the role of governors and presidents. Why is it happening? And is it a healthy thing to happen in our country? These are very important questions. There must be more and more public debate. These public, for instance, as an Attorney General, I have been receiving a lot of private members' bills. And since we are addressing an audience in Tamil Nadu, I have received a private member bill which says that we must amend the Constitution to say that in matters of appointment of governors, the state chief ministers and government should be consulted. I hope you understand the context. So Tamil Nadu has provided a context for it. There is no other part of the state where this problem has arisen. And we have some issues like appointment of vice chancellors in the state of Kerala. The governor has a problem with the state of Kerala appointment of vice chancellors. And vice chancellors are important parts of our educational system. So the important examples vice chancellors have been in our education system. Lakshmana Samadhyar, great example, Madras University. And Dr. Radhakrishnan. You are such wonderful examples of people being great, tall figures. So in several fields of public life, the governors and presidents would be ordinarily exercising power, which according to them is wise and mature. The court begins to look at very closely why they need to be accountable. So this idea of everybody being accountable, whether somebody who has served long years in prison should be released or not. So Rajiv Gandhi assassination, those convicts. So every aspect of the highest level of decision making by presidents and governors, if they are to be accountable, is it because there is something gone wrong in our country? Or because we as a nation begin to think that every institution in our country, every holder of power in our country should wield and exercise their power and authority in a way that every one of us feel comfortable and confident that nothing has gone wrong. That's I think, is an important social development. So with a constitutional development and a social development, there's a great nexus. So the social development is all of us begin to think that, look here, how do institutions function? And if institutions function in an accountable way, then we are comfortable. So the moment institutions do not function in an accountable way, then there's something seriously wrong, not only with those who wield power, but with the very idea of a constitution. So I feel very comfortable in saying that for 75 years, the Indian constitution, through the functioning of the court and through the electoral process, and the people with their wisdom and maturity, ultimately being the guardians and custodians of power. So the custodians of power, I think that's what has contributed to the great enrichment of Indian constitution and rule of law. When constitutional pundits from across the world begin to talk about rule of law, it's all about cliches and the oft-repeated, phrases they talk about. But I think when Mahatma Gandhi talked about ahimsa, he was talking about another great perennial civilizational virtue. That's part of our own tradition and culture. That everything we resolve in our, in interpersonal relationships is on the basis of ahimsa. that I shall not think wrong, I shall not do anything, think anything which injures somebody else, injures even unconsciously. So I remember, either it's in Manimegalai or Silapadikaram, the king goes to the evening to light a lamp in the temple lamps would not burn. The king asked the minister, Mr. Minister, have I done something unconsciously wrong that even the temples in our country will not burn? Have I done something unconsciously wrong? That is the highest level of dharma which you have practiced in our country. A king feeling, oneself accountable to dharma and unconsciously. But that is something which is so deep in our concept. I think, therefore, as people of a country, we need to look more and more closely and the importance of transparency, accountability, and the functioning of our institution and those who are voted to power. And that I think is the ultimate way of looking at constitution, the idea of constitution and all that. So having said that, I probably open to some questions and answers. As I said, I don't want to get into doctrinaire, Pandit-like constitutional dialogues and debates, like a classroom on constitutional law. As common men and women, it's important for us, I feel, again and again, that how do we really continue to be part of being a constitution? Just as I feel important, then I will stand up, get up in the morning and think that I must do this in order that my day begins well. If my religion teaches that, I do it so. Because it will become an internal part of my psyche. The way we function in everyday life, we order every aspect of our mind, our conduct, our thoughts, our interpersonal relationship. See, if you are so guided so beautifully by our culture, I think it's important equally for us that we try to build a beautiful connection between how we are culturally enriched and that we are also constitutionally enriched. We need to have this connection. It's important for us. So that's where I would like to share a few thoughts on what need to be in the Constitution and what not to be in the Constitution. And if Shanta has any, we can have a small question and answers. I think we'll probably get into that.
Sir, the audience would like to ask a few questions.
So, good evening, sir. I'm Narayanan. So, I would like to know about the ongoing turf between the Supreme Court and the central government in appointment of judges. How do you think that this should go and what is the solution for that, sir?
If I am the government of India, I would have answered it in a way. I'm not the government of India, not the Supreme Court. So I can answer this question only as the common man, and namely that if there is a law, then the law must be abided by. If the law creates a problem, then it is for the people to explore further solutions to the problem. There is no one called final say on many of these matters. And why we have a problem today, we must ask further questions about the problem itself. So there are two camps. I don't think each camp is final. Each camp is finally wise. But what is important as a common men and women, what's important, I think, is that if a court is constituted of persons with virtue, with moderation, values, understanding, and the great values of a country, that becomes, I think that's a great need for a country. So I would like to have a court constituted of such judges. So whether the current system would facilitate it, aid it, or does not aid it, is a question to be asked. Ultimately, whether government should appoint or judges should appoint is only one part of the story. So I think this part of the story is becoming occupying, the debate today. I wish this debate moves into other directions.
Thank you, sir. So Mr. Shyam Sundar of Indoi Analytics would like to ask a question, sir.
Sir, hello. Sir, we have been discussing about right or to speak or right of our any kind of expression. But is there any red line to be made or any right is right?
Well, somebody asked me this question quite some time back. What is this freedom of expression about at all? Why do we need to express ourselves? And if you ask a different question, why should religions engage in conversion? The ultimate value of communication between two individuals, I think, is the sharing of one's experiences. If my thought is noble, if my experience is noble, and something very wonderful about my experience, I must share. Sharing is all about freedom of expression. So if I have something so beautiful, I must share it with you. Poetry, literature, philosophy, culture, they're all noble aspects of human life. That's what we need to share them. And communication is a part of sharing. But our freedom of expression is not merely about sharing these nobler aspects of life. If only technology has not invented the new tools of communication, like two interesting books written about internet, Facebook and Amazon and Google. We don't now. It's become part of our life. We don't think we can live without them. In a way, it has become embedded in our life. But as somebody said, when the tools for communication have become more important than communication itself. So today, it's all these tools of communication become more important. We cannot also dispense with the tools of communication. So the question is, how do we really manage wisely the tools we have invented for communication without being lost in the ocean without a rudderless ship? So large amount of freedom of expression today is like high on the high seas without knowing where we want to really go. So if somebody were to tell us, our own culture and religion tells us to practice Maunavrat, in important times and every day, which means that you don't need to speak at all. You don't need to communicate at all. You need to communicate with yourself. So from communicating with oneself and drawing into silence, I find we are drawn into a world where only communicating with others 24 hours a day has become the pursuit of our life. So who is responsible for it? I don't think it is the court saying something, these are the limits of freedom of expression. That's only, I think, a very minimal part of the story. So as probably saints and seers will come and tell us that the freedom of expression is more important for nobler pursuits of life rather than other areas where we keep on talking. So somebody calls it in whether you use the word gossip and raise it to a higher levels of communication, well, we can do that. But the minds of every one of our mind becomes restless. If we don't talk to our neighbor over a period of time, become very restless. And today the restlessness has increased because the tools of communication have become part of our life in ways we never imagined. So how are you going to manage all this? It's a civilizational question. It's a question of culture. It's a question, ultimately, I think, of culture. I don't think law should enter into this debate beyond a point. And the moment law enters beyond a point, then we will have all kinds of encounters with law. Take examples like schools and educational institutions. You have so much of things to be done. If a teacher doesn't do this, if a principal doesn't do this, if a management doesn't do this, you get into problems. So the ethical, moral responsibility of individuals, namely teachers or managers of institutions, that seems to be slowly giving way to more and more of law. More and more of law. Then more and more of law means that we are moving more and more away from our own ethical and moral, basis and our ability. So therefore, on the one hand, we need to have less law, and but on the other hand, so many social problems and issues where law need to come in. This is another challenge. So we have regulation in environment. You can't do without it. If environment protected, you need a regulatory mechanism. So if we need to deal with any part of other aspects of life, we need some regulation. In economic aspects, we need regulation. Why are we not self-regulating? So when you ask the question about freedom of expression, I think we should expand it to every aspect of our life. Which is that famous quote when Adam Smith, when he wrote his Wealth of Nations, he talked about the butcher, the baker, and the candle maker. So he saw the invisible hand. Every one of them were, working not because they're concerned about social pursuit, but they're all concerned about their own, individual economic pursuits, which is called the invisible hand in economics. So there is some invisible hand which works much beyond what I call sometimes the human ability to be the managers of one's own self within certain limits. So these are very, very important social and philosophical debates. I don't know how much law can come in or how much law will take away. But I think we need to be constantly and perennially engaged in this kind of debates.
Thank you, sir. One more audience is very anxious to ask a question, sir.
Hello, sir. Good evening. This is Shiva Gurkal. My question to you is that on a similar, on a similar issue, different high courts are taking different views, which means that they are having a different understanding about the courts of law. In a layman's view, the laymen are not completely satisfying about our legal system today, because being a lawyer, every day we are interacting with common man, common public. People are hesitating to approach the court because they say that there are 4+ crores of cases pending across the nation in various courts. Actually, our legal system. Our legal system is supposed to help people to sort out their issue, but today our legal system itself become a burden to public. Do we need to rewrite our constitution or do we need to renew our constitution? This is my question.
I don't think the answers to your question will come from adding more and more to the constitution. As I said, our legal system is adversarial. We have borrowed it. It has come to us, the European, continent. But with several constitutional promises, we continue to work with the same adversarial legal system. And as long as we have the adversarial legal system, our legislation will continue to be based on adversarial legal. More and more rights, more and more courts, and more rights and more courts mean more and more cases and problems. So it is not enough to find fault with our institutions of justice for the enormous, pendency and the huge backlog of cases. As I said, if only we can move away from an adversarial system. Look at the kind of cases that will go to civil and criminal courts, and a good percentage of them can be handled outside the court system. So we are not still invented, and what one may call an Indian version of administration of justice, which can address the justice needs of different sections of our community. We put everything together in the same mold, therefore the answer is wrong. So probably the need is to move more away from court-oriented, litigation-oriented approach to resolving our problems, and having systems and institutions where problems can be mediated, resolved, and without getting into those huge debates on rights. The moment you have rights, it's impossible for any lawmaker or a person to come with a precision about what exactly is a particular right. So courts will differ in their understanding about what would be a particular right. And if you don't probably arrest this tendency and continue to move on the same trajectory, we will have these problems forever. So I've been thinking for quite some time that we need to have different kind of lawmaking, we need to move away from traditional, currently existing court systems for management and resolution of our disputes. Look at our family courts. I mean, are they really contributing meaningfully to anything which may add to the values of tolerance, etc., in our country? So there are different schools of thought even on that. So if I am an extreme feminist thought, I will say something. If I am contrary thought, then I will say something else. And therefore, both these conflicting points of view today have coming to the courts, and they play the role out in the courts. So courts are in a way victims of this, outside courtroom dialogues and debates. Therefore, more and more of the debates, more and more of this thought process, and the way we continue to find courts, we cannot resolve them at all. So we need to move away from them.
Thank you, sir. One more advocate who is practicing in Chennai would like to have a question to you, sir. We will try to restrict it, but still there are many audience who are anxious, sir. One question, sir.
Good evening, sir.
Good evening.
The criminals entering into politics, why the electoral law, the so-called election commissioners are not preventing them to enter into the politics because they are the lawmakers? Please explain.
No, I am not getting your question clearly. Please come back.
The criminals, people's representative of criminals entering into politics, and they become lawmakers. Why the election commissioners make electoral rule suitably to prevent them from entering into the politics?
But who should come into politics is the first question.
The criminals are coming.
No, I should come into politics, then I'll be happy, isn't it? So what is politics? Public management of administration of a country is politics. That's how we understand. But there is something beyond that. So all of us should become our own representatives. But all of us cannot be sitting in parliament. All of us cannot be sitting in assembly. Therefore, who should represent us is a question. Therefore, in order that somebody should be really and ideally suited to represent us, we need some kind of a legal framework. That legal framework will have to first filter people who should not be in any representative capacity sitting in parliament and legislature. And who should filter them? The ultimate authority to filter them will have to come through again through parliamentary legislation. And it is not the election commission alone which determines all that. The election commission plays very minimal role again. It acts as only in terms of the framework of electoral laws. But if you look at what has happened, as I said, pre-TN session, post-TN session, just use session as an example. So we have seen a sea change in our country. The kind of people who would not be otherwise eligible, would have been otherwise eligible earlier, is no longer eligible. Unfortunately, despite all these very stringent, limitations, people still enter into political life. That's something very serious. And who is responsible for it? Not the election commission, not the electoral laws, but the political parties. So there is some debate today whether political parties should also be treated as public, enterprises, should also be rendered accountable. That is an important debate which was undertaken. If political parties are not accountable as to who should represent them, who should become members, who should be eligible to become candidates, and so on and so forth, then where do we draw the line? So the line must be drawn by some kind of an serious ethical, moral debate within political parties. Serious ethical, moral debate.